Try it one more time. Plug in. Okay, so can everybody hear me?
Yes.
All right.
Yes, Your Honor.
What I'm going to do is put something on the record in general, and then it'll apply to all cases. All right. We'll go on the record for the May 5th, 2021 docket in the 13th District Court in Navarro County, Texas. And this is being, these hearings will be conducted through Zoom. Prior to starting these hearings, the court attempted to connect to YouTube with no success. Contact with the OCA this morning indicates as follows, and I'll go ahead and read the email from Kelly Thibodeau with the OCA. It says, good morning. OCA is receiving reports that Zoom is having issues connecting to YouTube for live broadcast. OCA is contacting Zoom but has no estimated time to resolution. OCA believes that courts can proceed with hearings after taking certain steps. If courts do proceed with hearings, OCA recommends that the judge make findings on the record that they are unable to broadcast due to technical difficulties, and that they record the proceedings to be made available upon request. Courts should also post a note on their YouTube channel landing page informing the public that they are having technical difficulties and that the day's proceedings are not live streamed but be made available upon request. Please check the Zoom application or www.texascourts.gov for updates. Thank you, Kelly. So the court at this time will make a finding that that due to technical difficulties beyond this court's control or Navarro County's control, that these proceedings are not being broadcast. The court has started at the beginning of this recording these proceedings on Zoom, which will be made available upon request, and I will also at some point this morning post this same message to the YouTube station. So with that, we'll get started. We'll go on the record then specifically in cause number D20 29145-CV. And this is in the interest of Frankie Knox Frazier, a child. And I have present, I have Randall Means, Casa, Kelly Myers is the attorney ad litem. I don't see counsel for the mother or counsel for the father present, but this is a motion to withdraw, I believe. So Mr. Myers, you may proceed.
Yes, Your Honor. And I checked this morning prior to coming on, and they had been served.
Okay.
So, and I had talked to Ashley Bassinet personally, and she had told me she didn't have any objection to it. But I had officially retired as of December 31st of last year, which had been postponed from July 31st of last year. And my hope was that in the first 3 or 4 months, we'd have all these CPS cases resolved. However, it's obvious that they just continue to be extended because of circumstances beyond our control. In March, I went to the doctor and I've got some medical issues that I need to address. And so based on those two things, I believe that these kids would be better represented by somebody who is going to be actively practicing law, whereas I'm trying to close my office up. And you said this was Frankie Knox Frazier, but it's also Zabella Hinga and Felix Hinga. I think those cases have been consolidated.
Yeah.
And my motion to withdraw, at the time, they had not been consolidated when I filed the motion, so I put both cause numbers. But I think it applies to both of those. And I'm not aware that anyone has any objection to my motion, Judge.
Okay. Mr. Means, you're the only other counsel here present. Is that correct?
Yes, Your Honor, and CPS has no objection. I believe I advised Mr. Myers of that previously by email, but we have no objection.
Okay. And Mr. Myers, I'm sorry, you said the other cause number was in reference to Ortega?
Oh, the other case is Ortega. Yes, it's another child.
Okay.
And I have visited with the child and the foster mom, but I haven't been able to in the last couple of months. I have been able to talk to Melinda Veldman, who has been seeing the child, but just because of, I just hadn't had the time with these issues I have.
Yeah.
But I think the child is well taken care of right now. And obviously, if someone else is appointed, they would probably have more time to check on the child and everything. But it's the same issue as in Ortega, which is D20-28949.
Yeah, and I'll get to that one in a second. So, and as far as the Frazier and the other children, that motion to withdraw will be granted, and I'll sign an order. I think I saw it in my e-file this morning, so I'll sign that when it's presented, and that concludes this hearing. We'll go then to D20-28949-CV in the interest of Elijah Ortega. And again, I have Kelly Myers present, Randall Means present, Costas present. I don't see Ms. Watkins or Ms. Basnet present. And Mr. Myers, do you want to just have the court reflect that your reasons for the motion withdraw in D20-29145-CV would be the same reasons in this cause number?
Yeah, yes, Your Honor. In the interest of time, we would ask that you do that. Thank you.
Okay. All right. And Mr. Means, any objection to that motion?
No, Your Honor, CPS has no objection.
Okay, that motion's granted. And that concludes that hearing.
Thank you, Your Honor. May I be excused?
Yeah, sorry for the delay in getting started. Mr. Myers, I wish you all the best.
Okay, thank you, Your Honor.
Okay. Donnie Barber?
Present, Your Honor.
All right. We will go on the record then in D40442-CR State versus Donnie Ray Barber. I have counsel for both sides present, defendants present. Mr. Barber, is that your full and complete name?
Yes, sir, it is.
Mr. Barber, it's the court's understanding that you're wishing to enter a plea of guilty to the offense alleged in the indictment. Is that correct?
Yes, sir, it is.
And sir, do you understand what you are pleading guilty to?
Yes, sir, I do.
Mr. Sipes, do you wish to waive a reading of the indictment?
Yes, Your Honor, we do.
The record can so reflect. Mr. Barber, I do have documents that appear at this time to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir, I did.
And did your attorney go over these documents with you, sir?
Yes, sir, he did.
Did you understand everything you've signed?
Yes, sir.
You understand, Mr. Barber, you have a right to have a jury trial and you're waiving that right.
Yes, sir, I am.
You understand also, sir, if you were found guilty by a jury, you would have a right to have that same jury assess punishment. You understand that?
Yes, sir.
Are you a citizen, sir, of the United States?
Yes, sir, I am.
And Mr. Barber, this is a state jail felony. It carries a range of punishment anywhere from 180 days up to 2 years in state jail and a fine not to exceed $10,000. You understand the range?
Yes, sir.
It's the court's understanding, sir, that you have entered into a plea agreement with the state through your attorney. Is that correct?
I'm sorry, I didn't hear.
You'll,
Yes, sir.
okay. And yes, the court, she's got to take down everything you say. And you understand the the court will not, the court will not agree to be bound by the plea agreement you've entered into. However, the court follows the plea agreement, it does cut off your right of appeal. Do you understand that?
Yes, sir, I do.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Okay, and sir, do you understand the consequences of pleading guilty?
Yes, sir.
Mr. Sipes is your attorney. He's there with you in the jury room during this hearing. Are you satisfied with his representation in this case?
Yes, sir, very much.
And Mr. Sipes, your client certainly appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor, I believe that Mr. Barber is sane, mentally competent to stand trial and understands these proceedings.
All right. The court at this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. In this case, I do have states one, a judicial confession signed by the defendant. State seeking to have that exhibit admitted.
Yes, Your Honor.
No objection.
It's admitted. Anything further from either side?
No, Your Honor.
Defense, Your Honor.
State have a recommendation?
Yes, Your Honor. The state's recommendation upon a finding of guilt is 12 months.
Well,
Yeah, 12 months in the state jail, probated for 4 years, $1,000 fine, $290 court costs, reimburse the county for a court-appointed attorney as ordered by the court, reimbursement of $180 payable to the Texas DPS Austin Crime Laboratory, community service restitution of 80 hours. Defendant must take a hair strand test every 90 days and be responsible for that. ADAC and DOEP, along with weekly AA or NA meetings.
Okay, and Mr. Sipes, is that you and your client's understanding?
Yes, Your Honor, the 12 months probated for 4 years. Correct.
Okay. All right, Mr. Barber, based on the evidence, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court, sir, that you are sentenced to 12 months in a state jail facility. However, imposition of sentence will be suspended for a period of 4 years. During this 4-year period, sir, you are placed on community supervision where you're ordered to comply with terms and conditions of probation. Do you understand that?
Yes, sir, I do.
Mr. Barber, do you live here in Navarro County?
Yes, sir.
Okay. You'll be reporting to an officer here in Navarro County, and then I will ask you, sir, do you read and write the English language?
Yes, sir, I do.
All right. Make sure you read through the order, sir. It tells you what you can and cannot do, okay?
Yes, sir.
If you have any questions, you need to ask your attorney or the probation officer that you're either doing your intake with or ultimately reporting to on a monthly basis, okay?
Yes, sir.
Um,
Thank you.
Now, Mr. Barber, the court has accepted the plea agreement. So at this time, you've waived your right of appeal, and I will make sure the bailiff she's going to come in there shortly and get your prints, and I'll give you your note. She'll give you your notice of judicial clemency that has been filed with the court. Okay.
Yes, sir.
All right, sir. That concludes this hearing. Hang tight for the bailiff to come in.
Yes, sir.
Mr. Barber,
Yes, ma'am.
can you report to the probation office when you're through with the court?
Yes, ma'am. All right, get my running shoes.
Yes, you know where the probation department is, right?
Yes, ma'am, I do.
Okay.
We'll be with you in a second, sir. Okay.
Thank you, Your Honor. Maybe we excuse from this.
Yes, sir. Yeah, if you need to go downstairs and do what you got to do, I know that you've been patient. So I'm sorry about the technical issues, but
We're good, Your Honor. Thank you. I appreciate it.
thank you. Mr. Barber, if you just want to hang tight, she'll be there in a second, okay? You can just give this to you. Thank you. Okay, Jared Carrera,
He's in the jail, Your Honor.
okay. Good to see Mr. Wilson back. I haven't seen him in a while.
Good morning, Jared.
What we'll do is pick up the new case first and then do the 2 revocations, okay?
That sounds good, Your Honor. Thank you.
Has he ever been arraigned?
No, Your Honor, I just noticed that too. I apologize, or I would have done a waiver, but I
That's
noticed it
fine.
last night.
That's okay. We'll do it now. And
Okay.
I'm assuming you'll waive 10 days.
Yes, Your Honor.
Okay. All right, we'll go on the record in D40693, State versus Jared Matthew Carrera. I have counsel for both sides present. Defendant is present. Mr. Carrera, is that your full and complete name?
Yes, sir.
Mr. Carrera, you stand charged with the offense of possession of controlled substance, penalty group 1, under a gram, and it's the court's understanding you're wishing to enter a plea of guilty to the offense. Is that correct?
Yes, sir.
And do you understand what you're pleading guilty to, sir?
Yes, sir.
Ms. Martin, do you wish to waive arraignment, formal reading of the indictment in 10 days?
Yes, Your Honor, we waive arraignment, formal reading of the indictment in 10 days.
Okay, record can so reflect. Mr. Carrera, I do have documents that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did you have an opportunity, ma'am, sir, to discuss these documents with your attorney?
Yes, sir.
And did you understand, did she go over these documents with you?
Yes, sir.
And you understood everything you signed? Is that correct?
Yes, sir.
Mr. Carrera, you understand you have a right to have a jury trial and you're waiving that right.
Yes, sir.
You understand you also have a right to have that same jury assess punishment should you have been found guilty by that jury. You understand that?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Sir, this is a state jail felony. It carries a range of punishment anywhere from 180 days up to 2 years in state jail and a fine not to exceed $10,000. You understand the range?
Yes, sir.
It's the court's understanding, sir, you've entered into a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
The court will not agree to be bound by the plea agreement. However, if the court does follow the plea agreement, it cuts off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Do you understand, sir, the consequences of pleading guilty?
Yes, sir.
Your attorney is Ms. Martin. She's present here in the courtroom with you. Are you satisfied with her representation?
Yes, sir.
And Ms. Martin, your client certainly at this point in time appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor, I believe he is sane and competent.
The court at this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, a judicial confession signed by the defendant. State seeking to have that exhibit admitted.
Yes, Your Honor.
No objection, Your Honor.
It's admitted. Anything further from either side?
No, Your Honor.
No, Your Honor, defense rests.
All right, state have a recommendation.
Yes, Your Honor. The judge's recommendation is upon a finding of guilt, 8 months state jail to run concurrent with his other cases, $290 court cost, $180 reimbursement fees to the Texas DPS Crime Lab, 164 days jail time credit, and reimburse the county for the court-appointed attorney as ordered by the court.
Ms. Martin, is that you and your client's understanding?
Yes, Your Honor.
Mr. Carrera, based on the evidence, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court that you're sentenced to 8 months in a state jail facility with court costs and restitution to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor.
Okay.
No, Your Honor.
All right, sir, you are sentenced to 8 months in the state jail facility. You'll be remanded to the custody of sheriff who will transport you to the appropriate facility to begin serving out this sentence. This sentence begins today. You are given credit on the sentence of 164 days. The court will make a finding at this time that you are presumptively entitled to receive diligent participation credit if and when that's received by the court. You understand that?
Yes, sir.
This will also run concurrently, sir, with any other sentence you may receive out of this court. All right?
Yes, sir.
All right, sir. In this case, you've waived your right of appeal. That concludes this hearing. We'll go to the other two cases. All right. All right. We will go on the record in cause numbers D35833-CR and D36558-CR. Both style state versus Jared Carrera. I have counsel for both sides present, defendants present. Mr. Carrera, is that your full and complete name?
Yes, sir.
And sir, are you the same individual that was placed on community supervision by this court in both of these cases?
Yes, sir.
And they were both drug-related cases, sir. And that time, when you were placed on probation, the court ordered that you comply with terms and conditions of probation. Is that correct?
Yes, sir.
Since that time, the state has filed a motion to revoke probation in both cases, and it's the court's understanding you're wishing to enter pleas of true to the allegations in both motions. Is that correct?
Yes, sir.
And are you doing this freely and voluntarily?
Yes, sir.
And do you understand, sir, the consequences of pleading true?
Yes, sir.
All right. Ms. Martin, do you wish to waive readings of both motions?
Yes, Your Honor, we waive.
Record can so reflect. Mr. Carrera, in both of these cases, I do have documents that appear to have your signatures on them. They are written waivers and stipulations on revocation probation, a judicial confession, and a waiver of your right of appeal. And that's again in both cases. Did you sign these documents?
Yes, sir.
Did you have an opportunity? Well, let me strike that. Did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that you've signed, sir?
Yes, sir.
You understand you have a right to have a contested hearing in both these cases, and you're waiving that right.
Yes, sir.
All right. Your attorney in both of these motions to revoke is Ms. Martin. Are you satisfied with her representation in these cases?
Yes, sir.
All right. And Ms. Martin, again, your client appears sane and mentally competent. Anything that I'm sorry, Mr. Craig, I keep wanting to call you she. Is there anything that he has said that would cause you to believe otherwise?
No, Your Honor, I believe he is sane and competent.
Okay. Court at this time will find that Mr. Carrera is sane and mentally competent, that he's freely and voluntarily entered his pleas of true, that he understands the consequences of those pleas of true. The court this time will accept those pleas of true and take appropriate action based on the evidence it has in front of it. In both cases, I do have states. One, judicial confession signed by the defendant. State seeking to have those exhibits admitted.
Yes, Your Honor.
No objection, Your Honor.
They're admitted. Anything further from either side?
No, Your Honor.
No, Your Honor, defense rests.
They have recommendation. I guess we'll start with the state jail felony first.
Yes, Your Honor. In D36558, the state's recommendation is 8-month state jail with all previous fines, court costs, and court-appointed attorney fees with 285 days credit.
Okay. Ms. Martin, is that your understanding on that?
Yes, Your Honor, that is our understanding.
Okay. Based on the evidence, the court will grant the state's motion to revoke probation. It's the judgment of the court that you are sentenced to 8 months in a state jail facility. Any reason why sentence should not be pronounced?
No, Your Honor.
No, Your Honor.
Sir, you are sentenced to 8 months in the state jail facility. You'll be remanded to the custody of sheriff who will transport you to the appropriate facility to begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 285 days. I'm not very good at math, but I think that's more than 8 months. So, and obviously I'll make a finding that you're presumptively entitled to receive diligent participation. But again, I don't know if this is applicable in this case as far as because you do have that credit. So This will run concurrently, sir, with the other sentence you just received and the one that you're about to receive in the other case, okay?
Yes, sir.
All right, and then, Ms. Sherwood, you have a recommendation in the final case.
Yes, Your Honor, recommendation for D35A33. The state's recommendation is 6 years TDCJ with 290 days credit. And that is upon adjudication of guilt, Your Honor.
Yes, yes.
Oh,
Right, I'm sorry, pleading true to the allegations upon a finding of guilt.
gotcha. And is that your understanding, Ms. Martin, 6 years?
Yes, Your Honor, with 290 days credit. That is our understanding.
All right, sir, and I may have, on this case, I may have indicated motion to revoke, and actually it was a motion to adjudicate. So, sir, based on the evidence, the court will grant the state's motion to adjudicate at this time. The court will find you guilty of the offense alleged in the indictment. It'll be the judgment of the court that you're sentenced to 6 years in the Texas Department of Criminal Justice Institutional Division. Any reason why sentence should not be pronounced?
No, Your Honor.
All right, sir, you are sentenced to 6 years in the Texas Department of Criminal Justice Institutional Division. You are remanded to the custody of the sheriff who will transport you to the appropriate facility, begin serving out this sentence. This sentence begins today. You are given credit on the sentence of 290 days. Any day thereafter, you're awaiting transport. This will run concurrently with the other sentences you've just received out of this court. All right?
Yes, sir.
All right, sir. In this case, you've waived your right of appeal as well as the other two that I've already stated on the record. That does conclude both of these hearings. Sir, the bailiff will come over and get some prints from you in a moment, and on the judgment and on the docket sheets, okay?
Yes, sir.
All right, sir. Do you have anything else pending?
No, not that we're aware of, Your Honor.
Okay. All right, sir. Good luck to you, okay?
Thank you.
All
And
right.
Mr. Craig, good luck.
Yes, ma'am.
If you have any questions, you know how to get a hold of me.
Yes, ma'am.
Okay.
And we got one more for the 9 a.m. docket, Guttery. Apologize for the delay, but
Not a problem, Judge.
oh, was this a competency issue?
No, Guttery, Your Honor.
Well, I have some.
I apologize, Your Honor. Yes, we do have a report in here from Dr. Taft.
Okay.
Yeah, let me take a look, see if I have that report still.
This was back on the original, putting him on probation.
Well, this one was from 1/28/21.
Oh, you are correct. I guess I guess you saw him in 2020.
Well, here's
Yeah, the date of the assessment was 10/29/20. And the date of the report was 1/8/21.
yeah.
I have one from 1/11/21 is the last report I have. That was a psychological evaluation. And there was also a competency evaluation, both done by Dr. Taft.
Okay.
And it does indicate he is competent to stand trial.
I'm gonna stand. All right. Give me 1 second to open this.
Yes, sir.
My bailiff had to give me a knife. But if I cut myself, please don't laugh. Fortunately, the folder's red, so you won't see it. That's good. But how do you close it?
Oh, no. Push
This is
the little, push
Not
the
like
little.
I'm gonna let you do it.
No, you have to. I'm gonna show you. See this? Push that down.
Oh, I'm used to having it
It's
in
bad
another
luck for
spot.
somebody else and you open it.
That's bad luck, Judge. You gotta let her, if you open it, you gotta shut it.
Yep. There you
Okay,
go.
we're all in luck now. Thank you. Okay, we'll go on the record in cause number D38726, State versus William Lee Guttery Jr. I have counsel for both sides present, defendants present. And before I go any further, there was a competency evaluation done, and it was ex parte, but it sounds like the state has a copy of it. Is that correct?
Yes, Your Honor.
Yeah, we
Okay.
did forward a copy of it to the state.
Thank you. And so, Mr. Johnson, I guess you have a copy of it too.
Yes, Your Honor.
Does either side object to the findings of, I don't know if it was it, yes, Dr. Taft's findings about competency to stand trial?
No, Your Honor.
I have no objection to it. I used Dr. Taft in the past, and his report seems to be consistent with his previous procedures.
Well, the court at this time will adopt the findings of Dr. Taft and find that Mr. Guttery is competent to stand trial. So we'll proceed then. Mr. Guttery, is that your full and complete name?
Yes, sir.
All right, Mr. Guttery, are you the same individual that was placed on community supervision by this court back in 2018?
Yes, sir.
And at that time, the court placed you on probation and ordered that you comply with terms and conditions of probation. Is that correct?
Yes, sir.
Since that time, the state has filed a motion to revoke probation, alleging that you violated terms and conditions of probation. Is that correct?
Yes, sir.
And it's the court's understanding this morning that you're wishing to enter a plea of true to those allegations. Is that
Yes, sir.
correct? All right. Are you doing this freely and voluntarily?
Yes, sir.
Do you understand, sir, the consequences of pleading true this morning?
Yes, sir.
All right. Mr. Johnson, on behalf of your client, you wish to waive a reading of the motion.
Yes, Your Honor.
Record can so reflect. Mr. Guttery, I do have documents that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did you understand the documents you signed?
Yes, sir.
Did your attorney go over these documents with you?
Yes, sir.
Now, you understand, sir, well, I don't know, did I say written waivers and plea? I think they were
Yeah, I believe you did.
Yeah, I believe waivers.
Yeah,
No, not waivers. He's,
yeah. Let me just make sure. These written waivers and plea admonishments on revocation, probation, judicial confession, a waiver of your right of appeal. You did sign these documents and understood them. Is that correct?
Yes, sir.
All right. You understand, sir, you have a right to have a contested hearing in this case, and you're waiving that right.
Yes, sir.
Your attorney is Mr. Johnson. Are you satisfied with his representation?
Yes, sir.
And Mr. Crawford, I think, was also your attorney. They're partners, but are you satisfied with Mr. Crawford's
Yes, sir.
representation? All right. Mr. Johnson, your client and Mr. Crawford's client, they appear sane and mentally competent. Anything he said or done that would cause you or Mr. Crawford any concern?
You know, we did have some concerns initially, and we had him evaluated by Dr. Taft. I've had a chance to review Dr. Taft's report and the procedures that he used and come to his conclusion. And at this time, I'm confident my client is competent and knows and understands what he's doing today.
All right. In short of your concerns that were addressed already, the court this time will, I mean, I shouldn't say short of, you did address that. So at this time, the court, based on the findings, based on what the counsel for Mr. Guttery said, the court will find he is sane and mentally competent, that he understands the consequences of pleading true. The court is prepared to accept that plea of true and take appropriate action based on the evidence. I do have in front of me states one, a judicial confession signed by the defendant. State's seeking to have that exhibit admitted.
yes, Your Honor.
No objection.
It's admitted. Anything further from either side?
No, Your Honor.
Nothing from the defense.
Okay. Does the state have a recommendation?
Yes, Your Honor. State's recommendation on a finding of truth or a pleading of truth. The defendant is ordered to 5 years TDCJ, all previous fines, court cost restitution. Defendant is required to register as a sex offender in accordance with Chapter 62 CCP and 414 total jail time credit.
414 days?
Yes, Your Honor.
All right, and Mr. Johnson, is that you and your client's understanding?
Yes, Your Honor, that's my understanding.
All right, Mr. Guttery, based on the evidence, the court will find you or grant the state's motion to revoke probation. It's the judgment of the court, sir, that you are sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division. Any reason why sentence should not be pronounced?
None that I'm aware of, Your Honor.
The court at this time, sir, will sentence you to 5 years in the Texas Department of Criminal Justice Institutional Division. You are remanded to the custody of the sheriff, who will transport you to the appropriate facility, begin serving out the sentence. The sentence begins today. You are given credit on the sentence of 414 days. And obviously, any day thereafter you're awaiting transport to TDC, you'll be receiving credit, okay?
Yes, sir.
All right, sir. In this case, you waived your right of appeal. That concludes this hearing. Mr. Guttery, the bailiff will come over at some point this morning and get your prints on the judgment, or print on the judgment, okay?
Yes, sir.
All right. Good luck to you, sir.
Thank you, Judge.
All right.
Your Honor, Mr. Guttery was mine. Can I be excused now?
Yes, sir. Have a good day.
Thank you.
And Your Honor, earlier when I guess you couldn't see, I said because it's Cinco de Mayo Day, was this an appropriate court attire?
Oh, I think it is. I think it is. As long as you have one for everyone to wear.
That's right. Thank you, Your Honor. May be excused.
Okay, thank you. Y'all have a good day.
You too.
You too.
Do I have counsel for both sides? I mean, for the state bar and Mr. Berry present?
Good morning, Your Honor. Jackie Wheatington for the Commission for Lawyer Discipline.
Mr. Berry?
Yes, Your Honor, I'm here.
Okay. Before we get started, do we have a cause number on this case? I got it from Denton County, but I don't see an actual cause number.
I have the cause number available, Judge, if you're ready.
Yeah, yes, ma'am.
It's 21-1940-431.
No, what I do have it on my docket sheet. It just wasn't, I didn't have anywhere. Okay, yeah, I see it now. Thank you. Okay, Leslie, you ready?
Yes, thank you.
And y'all may not have been here before. I put this on the record earlier, but for whatever reason, there's an issue with Zoom connecting to YouTube this morning. Not just, I thought it was just us, but it's statewide, or at least that's my understanding, because OCA did respond. And so I did make findings on the record earlier about why this was not being live streamed to YouTube. And so basically, if either side, and I'll put this on my YouTube station, that if either side requests a copy or a recording of this, that it is being recorded on Zoom. So first time I've had this happen. So. Okay, we will then go on the record in cause number 21-1940-431, Commission for Lawyer Discipline versus Byron R. Berry. I have the petitioner present through counsel Jackie, is it Willington?
Wheelington.
Willington, okay. And I have the respondent in this case present, Byron Berry. Mr. Berry, is that your name?
Yes, Your Honor.
Okay. Mr. Berry, are you at this point in time representing yourself?
I am right now, yes, Your Honor.
Okay. All right. I set this for a status, and this court is sitting by assignment from the Supreme Court order, miscellaneous docket number 21-9020. That was signed on the 26th day of February 2021 from the Chief Justice of the Supreme Court. So I set this for a status, I guess, to see where we're going with this case. The only pleading I have so far, or any court documents, is the actual petition. Now, if something else has been filed, I don't have it. Mr. Berry or Miss Willington, have y'all, has there been
Nothing has been filed other than Mr. Berry did file an answer on March 31st, I believe, he accepted service of citation and timely filed an answer. And then that is the only thing that appears on the court's docket as for filings. Mr. Berry and I have also exchanged the required initial disclosures. Those were last week, and we both exchanged that information. And so at this point, and I'm happy to answer any questions that the court may have. At this point last week, we were available, the discovery period open for exchanging discovery requests.
Okay. Mr. Berry, is that correct?
Yes, Your Honor.
Has there been a demand made for jury trial at this point?
No, Your Honor, but we anticipate doing that.
Okay. Do y'all have an idea of I mean, if that's going to be the case, obviously, we'll set that, and it'll need to be heard in Denton County, it sounds like. I'm just doing this because, I mean, this is the first one I've done. Usually I'm used to going to wherever the county is, but that was obviously some time ago when pre-pandemic. So this is a little different. So is there anything that we need to discuss other than just once I get that demand, then we'll go ahead and put it on a trial docket pursuant to the orders that I've reviewed from the Supreme Court.
Jackie, do you want to go ahead? Do you have anything?
Well, I was just.
Ms. Willington, I apologize. Go
Oh,
ahead.
no, that's fine. Just for housekeeping, if we get a date picked, I'm happy to circulate a scheduling order. If the court has one that they would prefer we use, I'm happy to use one from the 431st court where this is, I guess, venue is pending. And just, there are some, in case anybody reads up on the disciplinary procedure, 3.07, Rule 3.07 says things have to be heard within 180 days of Mr. Berry filing an answer, except for good cause shown. That 180 days is directory, it's not mandatory. So as long as we can all agree on a date that works for everybody involved and works for the 431st, so we have a spot up in Denton County to hold a jury trial, the scheduling order does away with any sort of directory deadlines that may appear in the disciplinary procedure.
Mr. Berry, do you have any issues with that?
Well, no, Your Honor, I will say that Ms. Tompkins, the original complainant, has sued my employer and has used this as leverage against us. And unfortunately, I'm just old enough and far enough along that I'm not going to allow that to happen. We do have a judgment, which she has filed a motion non-protunct. It's my understanding that the state either cannot or will not abate these proceedings pending final judgment on the in the civil case. But with the outcome that we've got in the civil case, I would anticipate that we'll be filing a motion for summary judgment in this case.
Okay.
And I would agree, Your Honor. I think that the facts as alleged by the commission are this is ripe for being determined, the facts being determined on, or matter of law being determined on summary judgment. Just as I told Mr. Berry, because we had a conversation about this, he had asked about abatement and rules and the disciplinary procedure at 1704 that basically says I can't agree to an abatement just because there's a proceeding similar facts. So the disciplinary matter, while it does have similar facts in the private matter, civil matter between Mr. Berry's firm, Mr. Berry and Ms. Tompkins, because of the nature of a disciplinary proceeding, we march on without having any sort of effect of what may occur in that civil action between Mr. Berry and Ms. Tompkins.
Got it. Well, as far as a scheduling order, I don't believe in trying to institute my own. So if there's one from the 431st, let's use that one. I don't ever like to bring, if another court's got something they're using, it makes it easier on everybody. So we'll do that.
Your Honor, if I may also, I think that in the scheduling order, generally they anticipate mediation, but I don't know if Ms. Willington has authority to settle. She mentioned march on. I'm not sure if that's even an option. I don't know if she's got that authority or if she's allowed to. But
That's a good, I appreciate you bringing that up, because that was going to be one of the things I brought up. But Ms. Willington, if you say if I ordered mediation, but you can't agree to anything, then, and I understand certainly your position or your agency's position. Is that correct?
And no, I must have misspoke. It's not that I can't agree to settle the matter. I can't agree to abate the matter.
Gotcha.
Okay. The dependency of a related in fact and parties because of the nature of a disciplinary proceeding. I think the disciplinary procedure provides for the fact that we can have mediation or any sort of dispute resolution. I would just ask, I only meet with my client once a month. So I would just ask if we're gonna have a deadline to mediate, with very traditional in a scheduling order, that it'd be enough time where we can get some discovery done, formal discovery done, and I have a chance to meet with my client, and then my client can authorize, to settle.
Okay.
and Your Honor, here in Denton County, we have a dispute resolution center. It's not unique, but it's kind of neat because you'll get for free some of us old guys that volunteer our time to the mediations, but we will have to have an order from the court to go through dispute resolution or get a mediator.
Okay.
We can certainly utilize that.
It sounds like y'all are able to at least work together in some form or fashion. Do you think y'all could agree on a mediator?
I don't foresee that being an issue at all.
Okay. I mean, Ms. Willington's been very, this is not my area, and she's been very informative and helpful so far.
Okay. Well, Mr. Berry, I'm at some point, if you hire an attorney, hopefully he or she will, I guess, file whatever. But for now, just so I'm clear, you are representing yourself in this matter as of today.
Yes, Your Honor.
Okay. Well, I guess if we can get a scheduling order in place that y'all can agree upon, I'll sign it when it's presented. Is there anything else we need to take up?
If I may, Your Honor, ask Mr. Berry, the program you're referring to, is that DCAP?
Yes.
Okay. So Your Honor, the 431st has some stock orders that I was able to pull up from their website. So I'll tinker with those and make them, tailor them to this case.
Okay.
Mr. Berry, for him to look at, and then hopefully we can submit something to you. Is the best way to get an order to your court is to email it to Ms. Butler?
I think so. That's something I was going to find out, and I won't bother y'all with those, but figuring out how to do e-file, if I even do it in this case, because I'm not in that court. So I don't know how it works. We'll figure that out. But yeah, I think email for now.
Okay. And with my other cases that I have a sitting judge who is not on the bench in the venue. Typically, if an order is signed, you sign an order that's been prepared by me, I copy all parties and I send it to, I e-file it as an order with the county of venues. So the order appears, but that's just because there's a lot of moving parts. I'm happy to do it however, if you would prefer to submit the order yourself, Judge, or one of your staff members, that's fine. But I'm happy to do it too.
If you get me an agreed order, then I'll sign it and we'll figure out how to get it back to the
county.
clerk's office. Yes.
Okay.
We have pigeons down here. I'll do that if I have to. Well, is there anything else we need to discuss? I just wanted to make sure that this case didn't just sit here, and so it sounds like we can move forward and get a schedule order done and hopefully that mediation ordered as well.
Judge, prior to entering a scheduling order, do we need to determine a trial date?
I think that would be good. Mr. Berry, it sounded like you said that you will be requesting a jury trial.
Yes, Your Honor.
Okay. Well, once you've made that request, then can we get a schedule order that reflects that date?
Yeah, we'll get with the court administrator.
Okay. Well, I mean, we all know what's going on in the world right now, so I know that there's going to be a lot of demand for jury trials throughout the state and throughout the country, I guess, for that matter. So we'll do the best we can. I would assume that Denton County probably, well, y'all tell me, have there been any jury trials up there recently?
Mr. Berry would know better than I.
I don't think we've had a jury trial. I know Cook County has, and I think Grayson, but I don't, I'll have to talk to the other attorneys here. I don't do litigation, so I haven't heard any of them say there was a jury trial now.
All right. Well, if they're like my minimum protocols, I don't know if I know that we have a big convention center here, so I know that y'all have one at least somewhere, if not the campus, the UNT campus or other places. So that's for another day, I know. So with that, I believe that concludes this hearing. So thank y'all.
Thank you, Your Honor.
Thank you, Your Honor.
Y'all have a good day.
You bet. Take care, Jack, Ms. Wigington.
Not a problem, Mr. Berry. May we be excused, Your Honor?
Yes, ma'am. Y'all have a good day.